A lot of law students have been asking me to talk about this, especially because of the fact that I always encourage law students to not shy away from appearing before a judge, especially for small miscellaneous stuff, which, anyways, otherwise, if the main counsel is not there, the matter will be adjourned. Therefore, it is better for the intern, the law student himself or herself, to appear before the judge, make those 5, 10, 15 words of submissions, and help assist the court in moving forward with the matter. What happened recently was it came in the news, especially big on the legal news websites, where the Uttar Pradesh High Court entertained a quashing petition under sections 419, 420, and 171 of the Indian Penal Code, in which apparently in the city of Raebareli, a law student appeared before a judge, made certain submissions, and the judge then directed the registration of an FIR. And because of this, law students come and say that because of this, now we are not sure whether we even have the slightest bit of right to appear before the judge or not. There are many factors involved, so I just wanted to make a small video about this. Of course, you're not supposed to stand in front of a judge and say that I am a lawyer, I am an advocate. And I presume that this whole debacle started with this law student appearing before the judge and saying that I am an advocate. Because I have seen this across the country, it has never been an issue when you do not wear a band, which was also the case in this particular case. You appear before the judge and you do not lie to the judge, and you tell the judge the facts as they are. It is, the judge is completely free to do as he or she pleases. Never have I seen anything come upon the intern unless some other transgression has also taken place. If the law student says I'm an advocate, of course. But even then, the maximum I have seen is the judge reprimand the law student severely, orally, without anything reflecting in the order sheet. And maybe in 1 out of 50 such cases, the judge also reflects in the order sheet, Mr. So-and-so appeared before me, claimed to be an advocate, and he has warned that this kind of thing should not happen in the future. Done and dusted, forget about it. But if you are afraid that if you appear before a judge as a law student and there could be an FIR registered against you, let me tell you this. In this absurd country, all sort of absurd matters, the cases are registered. Every single day, there will be, some FIR registered which has nothing to do with an actual offense. No offense has been committed either. But an FIR has been registered, the police will investigate. If there is some sort of animosity or there are some other, agendas involved, the police will arrest you as well. You will face prosecution. Ultimately, after maybe a few months, you will get a discharge, or the petition will be, the FIR will be quashed. Or maybe years down the line, after a lot of investigation and everything happening under the sun, you will get an acquittal. And everybody, including the judge at the time of passing that order of quashing or discharge or acquittal, will lament the entire system and the situation, and how and will severely castigate the investigating officers and the other people involved. But the damage is done. You are either arrested or you pay lakhs of rupees to your lawyers. Hopefully, in this particular case, this law student did not have to pay any money, because legal fraternity, we try to look out for each other. In any case, should you as a law student, after this incident, should you not appear before the court? I very strongly believe that. And in another context, a lot of clients always ask me, what about this? What about this? Are you sure about this? And I tell them that the more law I practice, the more I understand that there is no certainty of any sort whatsoever in this legal system. So rather than looking at those odd 1 in 10,000 situations, look at the rest of the 9,999 situations where nothing happens, and look at the upside. Very, very recently, and I posted this on Instagram as well, a law student who is interning with me, I had only given her instructions to appear before the judge and say that the main counsel is not available, but our submissions are already there on the record in the petition that is there. It's a very, very small matter, and even if that thing is not allowed, we don't really care. But it is something which, as a matter of procedure and as a matter of convenience to the court as well as the parties, this is something that could be done. Now, the opposing counsel appears, he also makes a submission, and this is the beautiful thing, in stark contrast to what transpired in this Raebareli matter. The judge noted down the name of my intern, Miss So and So, law student appearing as an intern for the main counsel, who states that the main counsel is not available today. However, she has apprised the court of the facts and circumstances of this particular case, and has made her submissions. The opposing counsel submissions are ABC, and I am convinced, and therefore the transfer petition of the petitioner is allowed, and we proceed with the matter. This was a transfer petition which we had filed, a small issue which did not have any major repercussions in any case. The point that I'm trying to make is that I have 100 such examples where law students who have interned with me, other people, the stories that I hear, other interns that I've seen, so many interns, law students who come up to me and tell me that they regularly appear before the courts in small issues. You're not making detailed legal submissions, detailed arguments. And sometimes you do. Sometimes, in fact, I have spoken with a few judges here and there who tell me that they appreciate a law student coming in and making his submissions, her submissions, and apprising the court. And another beautiful aspect about this is, on most days, if an adverse order, a bad order against the party is to be passed, and if the intern has made submissions, the judge will say, call your senior, and only then will I, after hearing your senior, pass the appropriate submissions. Whereas if a good favorable order is to be passed in favor of the client, the judge will hear the law student and then pass orders. Another aspect to this is, one aspect of course is, if you're not an advocate, can you appear? By extension of that same analogy, one could argue that even an advocate whose name is not there on the vakalatnama, or who does not have a valid document executed by the designated advocate authorizing him, how is he appearing and making his submissions? Let me tell all of you, every single day there might be 1,000 law students appearing in these courts across the country and making, 1 or 2 line submissions. But there are thousands of more advocates who without vakalatnama appear before the court, are effectively able to make their submissions and get the relief for the client despite their name not being on the vakalatnama. You can of course get into the hyper technicalities and say that if you're not authorized, there is a lot of scope for damage. Well, there is a lot of scope for damage for anything under the sun. And if you feel that an advocate who is duly empowered is going to do the job right, that is also a big question mark on most days anyways. So I would say, let us not focus on the hyper technicalities of what is supposed to transpire. We look at the pros and cons. We understand that the pros are far greater in weight compared to the cons, and therefore you should allow advocates who maybe don't have their name on the vakalatnama for whatever reason, but if they are authorized, and you should allow law students to also appear before the judge to make small submissions to push the matter forward to get the goddamn work done. Because most often you will have one counsel not being able to appear. And so today itself, I was giving this example to this friend who is not a lawyer, that on most dates, if there are say 10 appearances, on 3 occasions, the counsel for the plaintiff or the complainant or the petitioner will not be available. On 3 dates, the counsel for the respondent, defendant, etc. will not be available. On 3 dates, the judge will be on leave. And out of 10 dates, from experience, on most occasions I see, this is a system that we lament, all of us do, but this is what it is. And then on 1 out of 10 occasions, you will have an actual effective hearing where both parties are ready to make their submissions and the matter moves a little forward. In that kind of a situation, if I am held up in another court, if my law student comes and says that we had to file this document, we have filed this document now, we are handing over a copy of this document to the other side, and the matter may be fixed for a date convenient to both the court as well as the opposing side. If you do not allow a law student to do this much, one aspect is that their fear of addressing the court does not go away. They have to wait far longer. And more importantly, the thing which needs to be done, if the judge does not open the file and look at the document which has been filed a day or 2 prior, the judge will simply say, none appears for XYZ party, the matter is adjourned to so and so date. And so the matter could have been fixed for arguments. But because the main counsel is not there on the small aspect of maybe the supply of a document, or maybe to seek a passover, or to maybe just apprise the court that maybe there is a quashing petition which has been filed, or maybe we have approached this particular we have approached an appellate court in appeal and we've obtained a stay. Simple things like these, you should allow interns to go ahead and do this. Now the question again coming back to, should a law student looking at this incident, should that law student appear, live in that fear and never appear before a judge? My answer is, be careful of a few things, and if you are, there is nothing to worry about. One, never ever lie to the judge. Be honest, and if the judge chooses to tell you off and to tell you that you have no right to appear, bow down, accept it, and then move out. Second thing is, never ever wear a band. That is something which is exclusively the domain for advocates. You cannot wear a band if you're not authorized. Even if you're a law graduate, if you're not enrolled with your state bar council, do not wear a band. Third, when you go and stand before the judge, you do not say, I am here to address my arguments. And this is something that I have also done on a lot of occasions when I have worked for other people in the past several years ago, when my name was not there on the vakalatnama, and it did not make sense for the client to come down with a new fresh piece of vakalatnama with my name there to sign, so that I can make that 10-second submission before the judge. But this is something, and even lengthy arguments for that matter, because what I used to do on a lot of occasions was, and I've seen plenty other smart people do, is that you go before the judge, you stand there and you say, I am appearing for the petitioner. For an example, I appear for the petitioner. The main counsel is not available today, so I will have to seek an adjournment. But if my lord permits me, I would like to point out these 2 or 3 things which would help the court move forward with the matter. And then you leave it to the judge. If the judge agrees, here's those points, passes the decision, that's great. If the judge is one of those maybe 1 out of 100 judges, and the judge would not be at fault, the judge wants to follow that hyper technical point, to the letter, great, fantastic, good for you. But if that judge is one of those 1 out of 100 people, sure, you bow down and you walk away. And if the judge is out of those 99 out of 100 judges who says, I will allow the person to address these few minor things, and I can note down in my order sheet, proxy counsel for the petitioner, or intern for the petitioner, or anything that you might want to say, you say it, you observe the submissions being made. Of course, they should be valid submissions. You should read the file. You should not make floozy arguments in thin air. That is definitely something that should not be done. But if you've got the facts right, if you've done a little bit of research, and if you have put in a little bit of work, by all means, I say, don't let this 1 in 1 lakh situation deter you from going and making small submissions. A law student who interned with me back then, when she was a law student about 3 years ago, it took me almost half an hour of convincing for me to tell her to go to this particular district court judge and tell that judge that we have gotten the relief that we sought from this court, and we only seek that this matter may be disposed of, nothing else. It took me half an hour to convince this law student who kept raising this concern. The judge might scream at me, the judge may reprimand me, all of these things. And after a little bit of convincing and a little bit of rebuking, the law student agreed, went and made this submission. The judge just said, call your senior on the next date of hearing, and that was the end of the story. But what is interesting is, after this little resistance at the very beginning, at the first time that she appeared before the judge, she told me that a year later she worked for some other law firm, and she was able to effectively stand before the registrar of the Supreme Court, make a few submissions, and help in proceeding further with the matter. That same then law student is now doing very, very well as an advocate practicing law in the courts in India. A lesson for all of us, and something ancillary that kind of crops up over here as well, is the aspect of the fear, the apprehension, the resistance that a law graduate or even a law student feels when they have to appear before a judge. Just like any other thing in life, it is a skill which needs to be worked upon. How to stand, how to start your submissions. A lot of times when a law student or a lawyer appears before the judge, stands before the judge, they don't even know how to start with their submissions. They might have seen Hundreds of lawyers start their submissions, but their attention never goes on exactly how they started. But now that they are on that spot, they will actively, their mind starts working in that way. You know, again on a relevant note, when I interned with this senior as a law student, you know, it was a, you know, the internship was a breeze. I loved the internship. But when I had to go and work as an associate after getting enrolled as an advocate with that same senior, it was hell, because this time I actually had responsibility on my shoulders. And for everything that I was responsible for, I had to go there, make my submissions, be prepared. Or if I'm not prepared, I face ridicule by the opposing counsel, by the judge. I do not get the relief for the client. And then I come back and I face rebuke from the senior as well. And then the client as well. And because of all of this, I used to be in a constant state of anxiety and panic for the first few months of my practice. And again, I say this, that if I had somebody who would have told me that as a law student, you can go and make these small few submissions here and there, I know I would have been far more confident. So you learn from our mistakes, our regrets, and you proceed further. According to me, no law student should feel that I can have a case under cheating by impersonation, 420 also, imposed upon me just because I uh, just because I appeared before a judge. This person, even in this matter, this person did not wear any band. The person did not lie about being an advocate. The person just appeared before the judge and sought an adjournment. It is ridiculous. Happens all the goddamn time. But the good news is that the Honorable Uttar Pradesh High Court, the Allahabad High Court, granted stay on the investigation as well. And I believe no stay on the investigation, but directed that no coercive action should be taken against the petitioner, which you should note that the Supreme Court has deprecated the practice of especially the Allahabad High Court, granting if what is effectively anticipatory bail by saying no coercive steps will be taken in quashing petitions. The Supreme Court has said this categorically, but the Allahabad High Court continues to flounder this direction of the Supreme Court and will in all likelihood invite the wrath of the Honorable Supreme Court any day now. But in any case, coming back to the point, if you're a law student, I would say that this should not deter you from going and making these small submissions with the authorization, permission of your senior to assist the court in precisely the way that I put it out to you.